Well, hello and welcome to Manda Hadley. In this recording, we're going to be talking about how to contest a will. And in this country, at least, wills tend to be seen as a person's final word about how their estate should be distributed after their death. And while that may be the case in the majority of cases where the will stands up and those final wishes are met, an increasing number of wills are being torn up and rewritten by judges after a person's died, with cases involving prominent individuals seemingly in the news every week. So we're going to look at how to contest or challenge a will and examine what people can do if they object to the content of a loved one's will, and look at how people can reduce also the risk of their own wills being challenged. I'm joined today by Lorraine Walker, Solicitor at Manda Hadley. Hi, Lorraine.
Hello. Hello.
So let's just have a chat around this first of all. So why do you think there's an increasing number of wills that are being challenged?
Right, there's quite a few reasons actually. First and foremost, family life is far more complicated than it's ever been. Many people are on second marriages, many people are living together, so that's a certain reason as to why wills are being challenged. House prices are increasing, so estates are of a higher value, and potential beneficiaries are more reliant on inheritances than ever before, purely to try and get themselves started in life. The cost benefits of legal challenge, obviously with an increased inheritance pot, looks far more favourable as a result. More people are using DIY wills, more people are being diagnosed with dementia, and more people in the population, therefore their capacity can be often called into question. And finally, I would say that there's far more information about how to challenge a will than ever before, thanks to the internet and the media coverage of contested probate cases. So yeah, more are being challenged.
It's interesting you say that, Lorraine, in terms of more readily available information. So in sort of true legal terms, on what grounds can you actually challenge a will?
There are two bases on which a will can be challenged. The first is validity, and the second is under the Inheritance Act provisions for Family Independence Act 1975. And in short, we call that an Inheritance Act claim. And that's where a will fails to make adequate provision for certain categories of individuals. Turning to the validity challenge, there are several grounds. One of them is an invalid execution, being the circumstances in which the will was made. Lack of capacity, the person making the will may have lacked capacity at the time of the will being made. Undue influence may have been applied to the person making the will, so the will may not reflect the individual's true wishes.
Just going back to that point that you made there about sort of the will's execution, how would you actually demonstrate that it's been incorrectly executed?
Right, a will is invalid if it doesn't meet certain criteria. So first and foremost, a will has to be in writing, and it has to be signed by the testator, and the testator is the person making the will, or by some other person in their presence and by their direction. It has to be signed and acknowledged by the testator in the presence of two or more witnesses who were both present at the same time. And the will has to be witnessed, attested and signed by each witness in the presence of the testator. And if those correct procedures haven't been followed, then a challenge to the will's validity can be made.
Okay, so that's about an incorrect execution. What about the lack of capacity, which you mentioned earlier? That's another ground, obviously, that the will can be challenged on.
Yes. So in order to have capacity to make a will, the testator must understand that they are making a will and what its effect will be upon their death. They need to understand the extent of their estate. They need to understand and appreciate any claims that could be made against their estate. And they aren't to be suffering from any disorder of the mind that would impair or influence their making of a will.
And how does that differ from undue influence?
Undue influence occurs when someone is somehow coerced or compelled to make a will that they didn't want to make. So undue pressure could be placed on the testator to perhaps leave an inheritance to somebody who would ordinarily, but for that pressure, they wouldn't have done so.
Okay, taking all of those cases individually, Lorraine, are there any time limits that apply when you want to contest a will?
In terms of validity, there is no formal time limits, but we would say that you should generally try to make a claim or seek legal advice as soon as possible. And we say that because doing so will make it far more easier to find evidence in support of your claim. Courts can often reject claims where there have been undue delays. And finally, if you're looking to recoup any funds that have been distributed, it's far easier to do that sooner rather than later and before they're spent.
So realistically, from what you've seen, how difficult is it to demonstrate that a will actually is invalid?
Right. I can't tell you how difficult it is because that depends on a case-to-case basis. So we'd have to look at the evidence and the circumstances. And so we would say it's best to consult a lawyer to understand the chances of success in your specific circumstances as soon as possible.
And you mentioned the Inheritance Act earlier as well, which I know is different to the cases that we've talked about already. So how do you make a claim under the Inheritance Act?
Well, of prime importance, claims under the Inheritance Act must be made within 6 months of the grant of probate, otherwise you will be out of time. Claims can be made by certain family independents where they consider that reasonable financial provision hasn't been made for them within the will. So what is considered to be reasonable provision does vary again on a case-to-case basis. And so a court will determine things such as the claimant's current and financial resources, future and current, and their needs alongside that of any other person who may have such a need in the future. The current and financial resources and needs of any beneficiaries of the estate, the deceased obligations to the person making the claim and any other persons and beneficiaries, and any physical or mental disabilities that you or any of the dependents have. What I should point out here is that you can make a claim under the Inheritance Act even when there is no will, and so the estate has been distributed under the intestacy rules.
And finally, I guess, are there any alternatives to challenging a will in court?
Yeah, a couple of things. One of them, alternative dispute resolution. That's what we would recommend, and that's an obligation that parties are under the civil procedure rules. Engaging in mediation could often lead to a deed of variation, and that's the other alternative to challenging a will in court. And a deed of variation can be made once agreed, or once the beneficiaries, have agreed that they are happy to change how the assets are distributed in someone's will or by the intestacy rules where there is no will. It does, as I've said, need agreement of all beneficiaries, so there does have to be some direct discussion between beneficiaries or their solicitors to achieve it.
Okay, that's been great explanation. Thanks very much, Lorraine.
Thank you.
If you do want to get in touch with Lorraine to discuss contesting, challenging a will, the details follow this video, and Lorraine can be contacted at mandahadley.co.uk. Thank you.
Thank you.